So I'm going to give a very kind of broad brush look at changes in employment law and family law through hopefully a quick systemic overview. So first I'm going to talk about some of the significant changes that were made to the Employment Standards Act this past spring. Some of those have already come into force. Of those amendments, I'm going to talk about changes on hiring young people. There's 2 new job-protected leave forms of leave for critical illness or injury and in respect of domestic or sexual violence. And then the employer's responsibility around tips and the pooling of tips. These amendments that took place this past spring are the first significant amendments to the law in about 15 years. And they're intended to be the first stage of a multi-stage process for modernizing employment standards law. I'm also going to talk about the significant effort that was made to modernize the Divorce Act and to harmonize it with provincial family law legislation. Bill C-78 was introduced in the House of Commons back in May 2018, and it was assented to largely unchanged in June of 2019. And so these are the first substantial changes that have been made to the Divorce Act since 1986. And so during the presentation on the Divorce Act, I'm going to focus on some of the bigger picture issues, including sort of newly recognized duties that are going to fall on parties and on legal advisors. There's a new scheme for relocation applications under the Divorce Act. They've included a more robust analysis for understanding best interests of the child. And then also they've included family violence to make it more harmonized with the way that things are going in the provinces. A lot of the changes to the Divorce Act are going to be familiar to those of you who work with BC's Family Law Act, because a lot of the terminology is modernized now to reflect the changes in the Provincial Act. So we're talking in the Divorce Act now about parenting time and contact instead of about custody and access, which is what the Divorce Act previously had. And it'll remain to be seen through interpretation of these new provisions, where there are some differences in the drafting between the Divorce Act and the Family Law Act, whether those will end up being significant or meaningful differences, or whether there's going to be what I think is intended for some harmonizing of interpretation. And so the amendments I'm going to talk about today are all going to come into force or are expected to come into force on July 1st, 2020. So not in force yet. So my PowerPoint, unlike Danielle's, doesn't have any writing on it. They're just photos to distract you from me. But so don't feel like, wait, are there some missing? No, they're just lovely photos I found on the internet. So in terms of hiring youth or children, Section 9 of the Employment Standards Act is going to be amended to make some changes. Children under the age of 14 will not be allowed to work at all without permission from the Director of Employment Standards. Children aged 14 or 15 might only perform light work with the written consent of a parent or guardian. And light work is going to be defined in a regulation as a specific work or a specific occupation that's unlikely to be harmful to the health or development of a child who is 14 or 15 years of age. So we'll see what that comes to mean in the regulations. Section 9.1 of the Act is going to address the hiring of children in hazardous industry or for hazardous work. Children under the age of 16 are not to be employed in hazardous injury or hazardous work. Children at least 16 but under 19 years of age mustn't be employed in hazardous industry or hazardous work unless they have reached a prescribed age in respect of that particular industry and work, and so that'll also be determined by regulation, as will the definition of hazardous injury and hazardous work. Interestingly, the legislation says that it's going to be defined as specific industry or work that is likely to be harmful to the health, safety, or morals of a person under age 16. So sort of an interesting potential there for the legislation to, or the legislature to do some morality policing. But we'll see what that is. That's not yet enforced. But what is enforced are two newly recognized types of job-protected leaves. Section 52.11 provides for critical illness or injury leave, and that's unpaid leave to provide care or support to a family member of up to 36 weeks if that family member is under the age of 19, up to 16 weeks if it's someone who's age 19 or older. And this is intended to be circumstances where the person that you're caring for's baseline state of health has significantly changed and their life is at risk as a result of the illness or injury, and that the care and support required isn't something that you need to have be done by a medical professional. And family member, family member is defined in quite broad terms, which is great. It's either a member of the employee's immediate family or any other individual defined as such by regulation. And there is a regulation now in place. It became effective on June 24th, 2019. It's the Family Member Regulation 137/2019. And that includes this broad range of relationships for compassionate care leave and critical illness or injury leave, including a catch-all for folks who are considered to be like a close relative, whether or not they're actually related to the employee by blood, adoption, marriage, or common law. So that's great, the recognition that people have all sorts of relationships and family-like relationships in their lives. The second form of leave is leave in respect of domestic or sexual violence. And this is going to be section 52.5 of the Employment Standards Act. This applies to the employee themselves or to other eligible people, such as a child or another dependent who's under the day-to-day care and control of the employee. Leave is available under this heading for a number of reasons, including if you need to seek medical attention in respect of a physical or psychological injury or disability caused by domestic or sexual violence, to obtain victim services or other social services relating to this violence, to obtain psychological or other professional counseling services, to temporarily or permanently relocate, and to seek legal or law enforcement assistance, including participating for criminal or civil legal proceedings related to the violence. And for this type of leave, employees are entitled during each calendar year to unpaid leave of up to 10 days in units of 1 or more days, or in one continuous period, and up to 15 weeks. So there may be, your employer is not required to, but they may want you to provide some proof, and there is a provision there that you have to provide reasonably sufficient proof as soon as practicable that you're entitled to this leave. So we'll see whether that's something employers are really going to be asking for and what's going to be sufficient for that. Domestic or sexual violence is defined broadly to include physical abuse by an intimate partner or family member, including forced confinement or deprivation of the necessities of life, sexual abuse by any person, so not just an intimate partner or family member, attempts to commit physical abuse or sexual abuse, Psychological or emotional abuse by an intimate partner or family member is included. And that within that category is intimidation, harassment, coercion, or threats, including threats respecting other people or pets or property. As well as unreasonable restrictions on or prevention of a person's financial or personal autonomy, following somebody, stalking type behaviors, and intentional damage to property. So some of those reflect what we have as the definition of family violence in the Family Law Act. And then apart from experiencing this type of violence themselves, a child who is an employee or an eligible person will also experience domestic or sexual violence if they're exposed to it directly or indirectly when it's being experienced by their intimate partner or by a family member of that child. And I should say that there's a consultation underway that's closing, I think today at 4 p.m. Regarding paid leave for domestic or sexual violence. So the leave that I've been talking about that's already in place is an unpaid leave. And now there is consideration of whether BC will have paid leave for this type of violence. Some of the other provinces have that. So if you have a minute, you could go on the ministry's website before 4 p.m. today and provide some input into that if you haven't already. The next piece is around tips and gratuity. So now we have a definition of a gratuity, and it's not all that surprising. It's, you know, based on what a reasonable person would be likely to infer that a customer has intended to be kept by the employee or the person providing them with service. Things like service charges that are added on fall within this category. Sometimes, you know, when you go out to eat, they'll say that there's this service charge that's already been added to your bill, so that will constitute a gratuity as long as it's something that a reasonable person would infer that is intended for the person providing service. It doesn't include any sort of extra charges that maybe come about if you're paying by credit card or something like that. But what the Employment Standards Act tells us under Section 30.3 is that employers cannot withhold gratuities from employees, they can't make deductions from employees' gratuities, or require the employee to return or give the employee's gratuities to the employer, with an exception. The exception is if they are required to do so by law. And then there's an exception to the exception. The exception to the exception is that if the employer is required to remit gratuities to a third party and they don't do it. And then also, the other exception to this is, of course, where tips are being pooled. So employers can do this type of withholding where employer collects and redistributes gratuities amongst some or all of the employer's employees. And importantly, the employer is not to share in that redistribution of gratuities unless they are a sole proprietor or a partner in a partnership who's regularly performing to a substantial degree the type of work that's being performed by the folks for whom the tips would be pooled. I'm going to skip over the investigations complaints part. It's going to be in the materials you'll receive. So there are some changes, but it's of what I'd like to just skip ahead to the talk a little bit about the Divorce Act. So there are some overarching duties that are going to come into play as of July 1st, 2020 for the Divorce Act. Parties are, now there's going to be a section 7.1, that's going to set out specific duties that parties and legal advisors have under the Divorce Act. And they're not terribly surprising, although a few of them are. There is a responsibility to ensure that you're exercising your parenting time and any decision-making responsibilities or contact that you have with the child consistent with the best interests of the child. So that's now specifically set out, as well as parties must, to the best of their ability, protect any child of the marriage from conflict arising from the proceeding. I say good luck with that. It also does create a specific duty on parties to try to seek resolution outside of court. Section 7.3 is that the parties shall try to resolve matters through a family dispute resolution process to the extent that it is appropriate to do so, which I think is some recognition that it's not, that there are lots of circumstances in which that's not going to be appropriate, including situations of high conflict and family violence. And that also under section 7.4, parties have to provide complete, accurate, and up-to-date information. So wherever there's a requirement that there be information provided, that information has to be complete, accurate, and up-to-date. Parties have a specific duty to comply with orders, and they have to expressly recognize that they have to abide by all of these duties, which is sort of a bit weird because it's like setting out all these duties and then another duty that you have to abide by these duties. But clearly they were getting some information from folks around the country who practice in this area that this is not happening, so they've tried to do what they can. And so every document that formally starts a proceeding under the Divorce Act or that responds to a Divorce Act petition that's filed with a court has to contain a statement from the party certifying that they're aware of these duties that I just mentioned. Legal advisors also have duties under the new Divorce Act. They have to comply with duties promoting parties' consideration of reconciliation and the availability of alternative dispute resolution. The reconciliation one I find a bit bizarre. Basically under section 7.7 paragraph 1, unless the circumstances of the case are of such a nature that it would clearly not be appropriate to do so, it is the duty of every legal advisor, and that's also a defined term, who undertakes to act on a spouse's behalf in a divorce proceeding to draw attention of the spouse, to draw to the attention of the spouse the provisions of the act that have as their object the reconciliation of spouses, and then to discuss with the person that they're representing the possibility of reconciliation. This really seems quite bizarre to me, but it's there. As well, there's a duty to encourage people to resolve the matters under an alternative dispute resolution process, and that to inform the client of family justice services that are known to the legal advisor that might help in resolving the dispute. So a real focus on shifting people away from court and into alternative dispute resolution processes, and putting duties on both parties, but also legal advisors. There's some big changes. Whoops. Yeah. I'm just at time, but I'm going to very quickly, because we started a tiny bit late, very quickly just run through these, and I won't tell you anything about them. I just want to show off my slides. So this one's about relocation. Some big changes are coming in new section 16.9 around relocation. Importantly, relocation is only relocation if the move is likely to have a significant impact on the child's relationships. If it's not a move that's likely to have a significant impact, then it's not going to be a relocation. It's just going to be, a change in place of residence. So there's more on that in the materials, as well as some notable additions to the factors that are in the Family Law Act for the best interests of the child. Two notable additions that I'll quickly mention. We don't have these in the FLA, but one is each spouse's willingness to support the development and maintenance of the child's relationships with the other spouse. as well as the ability and willingness of each person in respect of whom the order would apply to communicate and cooperate, in particular with one another on matters affecting the child. To my mind, this is very optimistic of the legislature, but it's there. And they also have continue with the maximum contact principle that a child should have as much time with each spouse as is consistent with the best interests of the child. And now we also have express consideration in the Divorce Act of family violence. It'll remain to be seen how different this is from the FLA's definition. In first blush, the Divorce Act definition seems like it could be broader. Instead of, talking about unreasonable restrictions or prevention of someone's financial or personal autonomy, the Divorce Act just refers to financial abuse, which could lend itself to being interpreted in a more broad way, but we'll only have to wait and see whether this does actually just harmonize with what's already happening in the provinces that have family violence defined already. So I'm just going to stop there and pass it on to Carly. Like I said, this is all going to be in materials, and I promise the materials won't just be pictures. There'll be some writing in those too.